Okay, well, welcome to another edition of the Feller Group's monthly webinar. My name is Alan Feller, and today's presentation is something new, something that we haven't addressed in a previous webinar or other discussion. And it's something that's very important and something that I've been dealing with for pretty much my entire career. And it's estate planning for the LGBTQ plus community, as well as families that have estate planning questions and ideas. This is something that's very important. And I'm glad that we have everyone joining us today to go over this. And we're going to go in depth. And the reason why it's such a important part of what I have been doing my whole career is one of my earliest mentors was very active in the LGBTQ plus community and was not just a mentor, but also one of my earliest bosses as a young law clerk working in Manhattan. And so we saw a lot of the estate planning questions and concerns and issues of that community that they were dealing with. And this was a time before same-sex marriage was legalized, when there was still a tremendous amount of concern and question for the community. So I was involved during my earliest days doing this type of work. So it is something that I've had a long familiarity with, and I understand the issues. And that's why I really want to go in depth and really give my sense of how to properly plan for a community that needs this type of planning. And today, of course, June 17th, 2026, we're really going to dig in. And again, save all your questions to the end of the webinar. And then basically what we'll do is go through it step by step so you understand what we're doing. One of the big assumptions that we deal with when we do planning for the LGBTQ plus community is that we make assumptions, and assumptions are one of the biggest enemies when we have complexity in planning. And people assume that their partner or chosen family can step in without the documentation that you would do in any other situation. You can't assume that. You can't assume that everything will work out because you have made a life choice and you've put that person in a position of authority. Putting a person in a position of authority requires legal documentation. And if people think that marriage by itself and only itself will solve everything, they're wrong about that too. The last assumption is people assume that their wishes are obvious, even if they've made it known, communicated it to their loved ones, talked about it. Unless you write it down, unless you put those wishes into effect with a legal document, they may not ever take effect. The other major issue is when the law that is currently on the books doesn't match your life and things don't correlate properly. And one thing we talk about is legal definitions versus real life relationships. The things, the ties that bind, all the stuff that we do day to day that's pragmatic, that works for us. How does it match the law? And what can we do to make both parts get together and connect in a proper way? As well as, do you understand the difference between your chosen family, the people you have brought into your life, versus your legal next of kin? The law, as far as estate planning goes, really looks at things in one way. Who are your blood heirs? Who are your marital partners? Those are the relationships that govern and control legal estate planning. Your chosen family, people who are part of your life but are not entwined, again, they may be left out. And when you have a documentation requirement that's not met, when you have outdated old documents or have never done estate planning documents, this is a major problem. That could cause tremendous heartache to the people you leave behind. In fact, our key message, if it's not legally documented, it may never be recognized. So why is the LGBTQ plus community? Why do families deal with these types of challenges? Well, number one, your chosen family may not be legally recognized. And because you have chosen a partner, because you've chosen a relationship, and it by itself, that choosing doesn't have the legal effect without documentation. Estranged relatives may still have legal rights, and we'll go through examples of that. One of the primary examples comes when you have never done a will, a trust, or put beneficiaries on a beneficiary form for retirement accounts or for investment accounts. The law looks at your family in terms of who are your closest blood relatives. If you have a sibling, if you have a niece or a nephew, those people you may or may not have a good relationship with, will stand at the head of the line to take your assets if you don't make the proper provisions. Blended and co-parenting families create unique planning needs, especially when you have situations when you're putting together disparate parts of other people's families that have come together out of love and out of caring and respect, but they don't have the legal effect necessary to move assets to that person. Only legal documentation can do that. And again, laws don't always reflect modern family structures. I mean, the structure of elder law, trust and estates law. I mean, a lot of these things have been on the books in some form or another, since the dawn of time. I mean, estate planning rules and laws can be hundreds of years old that have been passed down. And of course, modern healthcare laws, many of them have been put in since the 60s and 70s, evolving very slowly. So they don't always match up with a modern family structure, how things work in this generation, in this time period. We live in a very unique and special time. People have the options to create families that I think a generation, 2 generations ago would have been unthinkable. And I think this is something that I really want to dig into. Marriage is incredibly important. The idea that any person can marry their loved one, and that's something that was only allowable by law within this last generation. It's incredibly important that you have that ability. It gives you so many legal rights. It gives you rights with Medicaid planning, with spousal refusal in New York when someone has a long-term care illness. Great things because of that. But it's not enough, because just being married helps only with inheritance rights. It helps with your hospital visitation, Medicaid planning, and so, of course, certain decision rights. New York has a statute that allows a spouse to make healthcare decisions in the absence of a healthcare proxy. So some of those things are greatly helped and assisted by marriage. But marriage does not automatically handle your incapacity planning. It does not help with the power of attorney. So if you just are married, that alone will not give you access to your spouse's resources, retirement accounts. Without a trust, marriage doesn't help you protect assets. And that's why asset protection, trust planning, you need those documents. And then, of course, even with long-term care planning, you need to have the paperwork put into place. Same thing with beneficiary designations. You still have to fill out the forms for your IRAs, your 401ks, your 403bs. That has to go into play. So what's actually at stake? Why are we discussing this? Why is this webinar so important? Number one, medical decisions. When you are in a relationship, whether you're married to your partner, living with your partner, have a long-standing relationship with your partner, having a medical decision, having a healthcare proxy, so important. That gives you that legal ability. Financial control. Who can access and control your accounts if you're unable to? A power of attorney, having the forms completed so your loved one can step in your shoes and take care of things for you. Same thing with emergency access. Having a HIPAA form, having a healthcare proxy, making sure that your partner, your loved one, can speak for you, can make important healthcare decisions, procedures that you need for your well-being, discharge planning, whether it's to facility, rehab, nursing home, assisted living, or coming home with care. That ability is so important. And then, of course, inheritance rights. And this is true about anyone in any partnership, whether it's in marriage, outside of marriage. If you don't put that information in writing, it could be a problem. So I hope everyone has your workbook if you've signed up or have requested the workbook. Our workbook, I want you to fill this out to the best of your ability. Again, when you write down your concerns, write it down, put it into writing. It'll make a difference. What concerns you most about planning before today? What did you assume would happen if you're engaged in a crisis, if something happens? What do you think is most at risk without a plan? What do you think? This is what I want you to write this down, because then we can answer those concerns. How confident are you that your current situation is protected? Do you know what you have? Do you have a folder with your documents? Have you and your partner or loved one or spouse discussed this in depth? What's your confidence level? Do you have the paperwork? What happens when you don't have a plan? After 30 years or almost 30 years of doing this, I have seen countless people come in without a plan, without documentation, and of course, the situation has already erupted. The emergency crisis has arrived. What happens? Well, number one, you have we call this the default system. That's one way of putting it. It's if you pass away and you have not set up a will, a trust, beneficiary designations, well, then the state decides who is in charge. And that sounds very Orwellian. That sounds like 1984. It sounds like something out of a sci-fi movie. And in truth, the state really is a set of laws. We call that intestacy laws, the laws of intestate or administration in the state of New York. And it just puts an order of who's entitled to get your assets. Obviously, if you're married and you have a spouse, your spouse will receive your assets when you pass away, especially if you don't have a will. If you have a child and a spouse, then your child and spouse, if you don't have a will or any other documents, they will split with the spouse getting the first $50,000. Of course, if you don't have a spouse, you don't have children, you may have a long-term partner, and you don't have a will or a trust or beneficiary, then your next closest relative may get it. It may be a parent who's still alive, who survives you. It could be a sibling that survives you, that inherits everything. Could be a niece or a nephew. And this can be a problem if you don't have that kind of relationship with those survivors. Of course, legal next of kin hierarchy is, again, that's what we're talking about. That's what the intestate system is in New York. That's what administrations in New York, when a person has to handle your estate, they're going to file this paperwork, administration petition with surrogates court of the county in New York where you died and lived, basically your residence. That is going to be the place they file. And yeah, that person can receive your assets, whether you wanted them to or not. The law in New York does not automatically recognize your intent, what you have written down, what you have said. If you haven't put it into an official form, a will signed by the testator or testatrix, two witnesses, notarized affidavit, either before or during the will or after the will. All these things have to be done to avoid this default system. And then jumping right into your medical decisions. Now, of course, if you don't have a healthcare proxy, if you don't have HIPAA forms, living will, if there's no one available to make those decisions, if you don't have that protection through those forms, again, the doctors must follow legal authority. If you don't have a DNR, they may keep you alive beyond what you would normally think is a good decision or a good capability of yourself to enjoy your life. And of course, a partner, a legal partner without the legal protections. Let's say someone who's living with you but is not a spouse and they're not related to you. They, of course, will not have access or say without legal documentation. There'll be someone that visits you and provides care, but legally, the medical staff and personnel don't have the ability to give them that kind of authority. Give them a healthcare proxy. Give them a HIPAA form. Make them part of your medical decision-making. And of course, when you don't have documents in place, you have delays Because the thing is, when you get sick and you need a procedure or you need to have your discharge planning set up for Medicaid purposes and Medicare purposes, all the things that converge when somebody gets sick, you don't have the person to make decisions. You don't have that point person. Delays. And delays cost you tremendous money. Co-pays with Medicare, Medicaid not covering, so private pay balances accruing. Very, very bad. These are incredibly expensive mistakes. Please don't make it. Get your forms, talk to an experienced estate planning and elder care attorney to avoid that. So financial control without planning, we call these things powers of attorney. There are some older expressions people call durable versus springing. You can put language like that in your power of attorney. For most people, if they have a good relationship with the people appointed, they can make a durable power of attorney, which just means it goes into effect immediately upon its execution. So we create a form and make your loved one, your partner, your power of attorney, your agent under a power of attorney. They can make decisions immediately. This way, anything is possible. If you're concerned that you don't want to have control lifted while you're still functioning and still okay, mentally, physically, you can put what's called springing language into your power of attorney. It means only when you have reached a point of incapacity, you're incompetent, then your agent, your partner, can become a financial decision maker. So having a power of attorney is so important. Because without a power of attorney, no one can act on your behalf, pay your bills, move investments around, protect the assets if you get sick. Accounts may be frozen because without this financial control, something happens. Again, now we see this mostly when people pass away and there's no joint account holder, then that account may be frozen. Your partner who's paying bills, who needs their house that you've been sharing for 30 years, mortgage, taxes, utilities, they may not have access to funds to pay it, especially if it was coming out of your account. Have all that set up ahead of time. And of course, if you don't have a power of attorney and you become incapacitated and no one's taking care of your finances, the only solution for someone close to you would be an Article 81 guardianship. And that is very expensive, very time consuming. And again, it puts the partner who's not, related, not a spouse, not a family member, in a hard spot because they're coming to the court. They're saying, well, I've been together with this person for 30 years, for 40 years. And meanwhile, there's a sibling or another relative. The court's going to have some decision making that may not be what your person wants. So let's go through some real life scenarios. That's the best thing we can do. Reading this, Alex and Jordan, to use some names, have been together for 18 years. Alex is suddenly hospitalized and unable to communicate. And this happens a lot. We're in this situation. What do you do? So for medical decisions, let's say there's no healthcare proxy for Alex. Alex never did it. Jordan may not automatically have authority to make medical decisions. In fact, they may have to pull a relative, a nephew, a niece, a sibling to make decisions. And again, if Alex doesn't have a good relationship with Jordan's family or there's been problems, this is a really tremendously stressful situation. Now, as far as medical information goes, we're talking about HIPAA forms, whereas medical decisions, we're talking about healthcare proxy. Without a HIPAA, healthcare providers may limit what information can be shared to Alex. Basically, this is, in terms of the ability, what Alex was dealing with, Jordan couldn't gain access to those medical records that he would need. Very difficult. Now, financial control. Without a power of attorney, of course, paying your bills, managing accounts. How are you going to, how is Jordan going to pay the bills? Alex, without power of attorney, you can't do it. You have to do guardianship. Of course, and then after the crisis, without an estate plan, let's say they never put anything in writing, never set everything up, there's a chance that Jordan could be left out. Let's say Alex and Jordan lived in a home that Alex owned, and they've been living there for 30 years. Alex passes away. Jordan is not on the deed, and it goes into his intestate estate, goes through the courts. Surrogate's court will then issue decree. You'll have letters issued. And the thing is, it could be a sibling. Someone gets the house and not Jordan. Jordan can't live there anymore. very troubling. So this is also what leads to conflict. Conflict becomes inevitable when you have multiple people with equal authority, especially if there's nothing in writing and you have a partner or another long-time relationship, and you may have a sibling or a parent. And then this conflict without documentation can really go bananas. Of course, same thing with differing opinions and emotions. If you don't put things in writing, you then create conflict, because then nobody exactly knows what the intent is, and then people's relationships can be diminished. Same, lack of clarity. That's what we're talking about. When does conflict become inevitable? When there's nothing documented, there's been no real conversations about it, nothing has been set up so we can have clarity. So what is the cost of waiting to do this? If you don't put this into motion, you don't make an estate plan now, you don't get things in order, of course you get delays in care. Legal fees go through the roof, because instead of having a trust or a beneficiary is up to date, then we have to go through the courts, lawyers' fees, court fees, very expensive. It's a waste of money and time. Emotional stress. By waiting to do this, you've put your partner or even your spouse into a bad position because things aren't fully set up. So you have to make sure that things are in writing. And of course, the worst is outcomes that don't reflect your wishes, family members who you want nothing to do with, people who have not approved of your life and the way you handle things, people who have not agreed to how you have led your life in terms of being in that community, being in the LGBTQ plus community. Do you want a person who doesn't approve or doesn't agree to get all of your assets? I think that's something you wouldn't want. So, of course, write down all of the things you think happen without a plan. What do you think about who would make legal decisions for you today? Can you write that down? Use your workbook. Write down not just what do you think happens without a plan. You know what I've told you. And who is the person who would make decisions for you? You have that person in mind, or is there someone else? And of course, what are your worries about the situation? You have individualized worries. You may worry what happens if you get sick. You may worry about what happens, who's going to pay for the house, who's going to take care of your dog or cat. These are all things you have to think about. And of course, how likely do you think conflict is going to be in your family without clear directions? Does your family get along with your partner? Does your spouse and everyone get along? Or are there issues? So the tools that create clarity, we've mentioned the problems, and we always do this. I mean, every webinar is, here are all the problems, here are all the things that cause trouble in your life. And we always start that way. I guess that grabs people's attention. I'm not a big fan of scaring people on a daily basis. Maybe, every once in a while we'll do that. But let's dive into the tools that create clarity, that give you a sense of relief. Because ultimately, our job is to give you peace of mind. That's why we're here. We're not here to scare the heck out of you. So again, the same thing is when we talk about not having the control, not having things in place, our planning, estate planning, elder care planning, it's all about control. Again, you start the process. Whatever happens later is something that you have set in motion. We'll talk about irrevocable, revocable, but in the end, you have put this plan into place. You're in control. So number one, you decide who acts for you. You decide what happens to your assets, to your life. What is going to be is because of you. And of course, you remove uncertainty. Number one, our favorite healthcare proxy. You choose who speaks for you if you cannot. If you can't advocate for yourself, you can't give yourself a chance to direct the form and style of your care. The person you pick makes that decision. It gives legal authority to someone you trust to make healthcare decisions for you. And of course, it avoids family disputes during a medical crisis. Everyone knows the doctors, the hospitalists, the social worker, the staff, discharge planners. Everyone knows who to speak to. And of course, with a healthcare proxy in the state of New York, one healthcare proxy can be appointed at a time. You can have backups. So you could have your spouse, your partner, your companion. That could be your first healthcare proxy. And then you could have a group of people, one at a time, following that first healthcare proxy, but only one. Power of attorney. We discussed it already, but you're giving an agent under your power of attorney. That's the term that we use, an agent. And that could be more than one person. You could have your partner or spouse. You could have them with a sibling if they get along great, or another friend or someone important. You can make them co-agents with each agent acting separately. So let's say you have your spouse or your partner and you have your sibling. You could have each acting separately. So if one's in the country, one's traveling, the person here can make decisions without needing the other person. Or if you don't trust people to that extent, you can have multiple people acting together, only together. They can't act separately. Or you can pick one person at a time and have backups. You can do that too. You can always have backups. But of course, power of attorney is a person who's making financial decisions, has financial authority, and you're giving them immediately. That's why things have a durable nature. Of course, it avoids court involvement, no Article 81 guardianship for the most part. If there's really big disagreements with the power of attorney, sometimes it goes that way. Try to be nuanced about it, but most of the time it avoids an Article 81 guardianship. And of course, keeps things running smoothly. So if you become ill, the transition points are very smooth. Person can give the power of attorney, and hopefully the companies or the banks or institutions will accept it and approve and allow that person, your agent, to pay for things on your behalf. Little side note, some banks, some places can be a little more scrutinizing of your power of attorney. So sometimes it's good to put your power of attorney and file it ahead of time before you get sick. Just a practice note. I always recommend, if you're able to do it, have it on file. Wills and trusts. Hey, we've been talking about wills and trusts for so long, it's like second nature. What is a will? What is a trust? So number one, a will directs your assets, how to be distributed, and it's after death. It can be more general, it can be looser. It doesn't have to necessarily be specific, although it can be very specific. And a will can have trust built into it. So a will is basically your set of instructions after you die. The big issue with wills is that when you die and your assets that are in your name alone, let's say you have a bank account or you have investment accounts under your name, your social security number, no beneficiaries, no joint account holder, it's just yours. Let's say you have $200,000 in it. That asset is either a probate asset, administration asset. So the person involved with your estate, with your will, who's an executor, they will have to file a petition with the court and then go through surrogate's court to get what's called letters of appointment, letters of administration, letters testamentary. That's your court order, allows you to go back into the bank, get that money out, put into an estate account, and go through the estate process. But it's time consuming, can be expensive, lawyers and creditors could come out of the woodwork and file and claims against your estate. It's not the ideal way to deal with your money in the estate when you pass away. Now, of course, while a will directs assets after death, a trust that you create while you're alive can create and allow for private controlled distribution, and it avoids probate. So what you can do is, with your trust, unlike a will, you can have your property, your home, assets, basically transferred or put into your trust. And your trust names a trustee. A lot of times it can be you to start. It can be a loved one as a backup. And then they will direct where things go based on your instructions. Doesn't go through the courts, doesn't go through surrogate's court, no probate, no claims. It's more difficult to stop. It's a great way to move assets without courts. Now, of course, why is this important? Because if you have a will, and your control over distribution, yes, you can have control over it. However, with a will, you have to notify all your blood heirs. So even though you have either written people out or disinherited people, if with a will, everyone who's a family member, who's blood relative or a distributee, has to be noticed. Now, of course, that doesn't include everybody. If you pass away and you're married, then no one has to have notice. But if you're unmarried and you have siblings or nieces, nephews, and even if you don't get along with them, they would have to be noticed. If you just have a will and it goes through surrogate's court and no spouse and no children, keep that in mind. But still, I always say, if you have a will or a trust, Still better than nothing, because if you have nothing, you'll get beneficiaries who you had no intention of giving things to. Whereas with a will and trust, you control where things go. So, of course, you avoid unintended beneficiaries, and you're protecting your partner and your chosen family. The people closest to you will get the house and whatever assets, where if you don't put in writing, that could go to someone you don't want to have. So again, protecting what matters. You're talking about protecting your loved ones, your spouse, your partner, your companion. You're ensuring that an unmarried partner, a chosen family, people you have put into your life, let into it, are legally included in your estate and are protected. Of course, you prevent the administration laws, the intestacy laws from taking assets away from your loved ones and your chosen family. Of course, you're reducing conflict too. A lot of times what we'll do is we'll create things called family agreements, where let's say you have a relationship, companionship, and everyone in the family knows the bond you have with your partner, and everything that they have and own is joint. But you want to avoid potential conflict. There's relationships that are also more complicated. Family agreements can put that to rest. As far as other considerations that kind of ride alongside wills and trusts, make sure your beneficiary designations are updated. For most people, you have a retirement account, you have investment accounts, you'll have beneficiary statements, transfer on death statements, things going directly outside of probate, outside of courts, outside of a will and trust, goes right directly to that person. Life insurance. Make sure all those beneficiaries are up to date, especially if you're not married, not with a partner. You want to make sure that person that you love and care about is getting the assets that you want them to get. Put in writing. Make sure your beneficiaries are up to date. And of course, with a trust, and I'm a big proponent of trusts, and I think, again, for the individuals and the people I've known for decades who reside in the LGBTQ plus community, who have fought for rights and have pushed to make their lives and the lives of their loved ones better. The fact that you can put things into trust, taking it out of the courts, taking it out of complicated family relationships, just moving and directing it right to that person is so important. Trust can set instructions, guidelines. You can be really expansive with it. It's a really wonderful tool. And of course, you choose your trusted decision makers. A lot of times it will be your partner or spouse. Sometimes it could be a family member, a really close friend that you've had for decades. This is your call. We're here to help. We're here to give you some advice and give you that guidance, but this is your life. And of course, revisit your plan regularly. You did in 2005, you did in 2012, 13, awesome. I'm very happy you have it. I'm glad you did some work, but don't just put it in a drawer and forget about it. Things change. The laws have changed. The family relationships have changed. The people have changed. Someone that was nice to you in 2005 may not be so nice now. Or people who were really non-entities as far as you're concerned back then are now super involved in your life. Please revisit your plan regularly. That's why we're here. And of course, why these tools work together, what's so important. If you have your medical documents, your financial, legal alignment all together, one clear plan, no gaps, things are smooth and easy. The people around you can get things done for you. In an emergency, something happens, you don't want complexity. You don't want things not working. I like to have things in alignment. I mean, the danger of having multiple trusts and multiple things from different people, different professionals, not in alignment, you could have conflict. So when you write down in your workbook, what's your preparedness look like? What documents right now do you currently have in place? Do you have your folder in front of you? Do you know where your folder of documents is currently located? What do you have? What don't you have? And of course, what part of your plan are you least clear about? You may know exactly about your power of attorney, you know about your healthcare proxy, but maybe your trust you're not familiar with. Or maybe the will doesn't make a lot of sense. Again, a skilled professional can explain it to you and give you a real sense of what matters. Of course, what matters most when choosing decision makers, this is your call. You're writing it down. Is it reliability, consistency? Is it a good head on their shoulders, intelligence? If for healthcare proxy, were they a nurse or a doctor? Is it something that's tied to their profession, or is it your relationship with you? You choose that. And of course, what tools do you think you need and why? You may feel like you need more power of attorney, will, and trust than healthcare proxy. I say you get everything, but you know your own life. So protecting your family structure. This is a big one. And again, when I started doing this work as a young law clerk and working in this environment, family structure was so important. Second parent adoptions, other things to build a family in the LGBTQ plus world involved real thought, real creativity, real understanding. This was in a major part before a lot of legal rights were granted. And we're talking 28 plus years ago. This was a major component of the work that was being done. So again, you recognize your family. What does your family look like? You have your legal relationships, you have your emotional relationships. You have the people who are tied to you by blood and the people you have brought in who make your life complete. And you can combine the two. Obviously, the law has allowed marriage, and same-sex marriage has opened up horizons that we couldn't imagine 20 years ago. And you ensure that the people you have chosen, whether they're people that you have married, people that you allow to be in your life for a long-term period, make sure they're included, make sure they're part of your world, and avoiding exclusion, of course. What is your family? Ultimately, it's the people closest to people that you have put in your life to be there for your life. Again, marriage is not the full solution, as we talked about earlier. Being married alone without a will or a trust, is again, it's not perfect. Marriage does afford rights. It does give you legal protections. But if you have not updated your will or done this and you have a spouse that you've added, not updated your documents, they can go into what's called a right of election, or there's other things they can get 30% of the estate, but you don't want that. You want them to get the full estate put in writing. Same thing with healthcare documents, financial power of attorney, put that in writing. Your relationship, your spouse, the loved ones that you've added into your life, put that in writing. Put those documents into place, and especially understand your beneficiary designations. If you put a sibling down 20 years ago, never updated it, got married, that doesn't necessarily mean your spouse is going to get it. It means, there may be some issues. You may be able to file documents to get something, but, beneficiary designations may override your wishes. That's very important. Update your beneficiary forms. And the same thing with having a complete plan, beneficiaries, wills, trusts, put things together, make it complete. So how do you avoid unintended outcomes? By doing the work that we talked about, setting things up, meeting with a licensed professional, going through all the estate planning, elder care ideas. Again, you don't want the assets to go to the wrong people. You don't want a sibling you don't speak to, a nephew you've never met to get your assets. And of course, you don't want a family overriding your wishes. You don't want someone coming in who you didn't want to make healthcare decisions or financial decisions that you had no interest in doing. Have it in writing, set everything up early before anything happens. Okay, you don't want gaps in authority. You don't want people coming into your life that you didn't expect, that don't approve of your lifestyle, that don't approve of your partner, don't approve of your spouse. You don't want to put all those cultural markers, all those things that have really affected the LGBTQ plus community for decades to come into play. You want to paper it completely. So again, what's your long-term protection strategy? You update your plan over time as things change. Marriage, children, moving, new job, things that happen in your life, you update your estate planning, you update your long-term plan. You also align your documents with life's changes. A marriage may have ended, a new marriage began. Relationships ends, take that person off your documents, add someone new that you add into your life. Or put family in where family fits, or take them out. Making sure everything aligns completely. This is a good time to really examine what you have, talk to someone who knows this world. Keeping everything current, of course, know the law. Talk to a lawyer that knows where the law is going, what things have been happening, and how, practically speaking, things work. How do you protect children in a blended family? Every single family is different. People come in and they think there's a cookie cutter approach, or we just say this in a rote form. No, every family is different. You may have biological children, adopted out children. You may have stepchildren. Everybody has different rights. If you pass away, your stepchild may not have any rights to you. Biological kid would. And sometimes adopted or adopted out kids may or may not. So these things have to be put in writing, protect the children you want to protect, and the ones, of course, that you don't have to. Beneficiary designations also don't reflect your current family relationships. We just talked about that. Put everything in writing. Now, of course, when you have clarity and you have your wills and trusts and your wishes are carried out, then the conflict between the survivors also doesn't have to be a mess. Because one of your legacies, besides your assets, are the relationships you leave behind. Do your children get along with, does your partner get along with your family? Do things work so that the survivors can have a great life? Again, life changes matter. The things that happen in our life, and I keep repeating it because it's so important, because we lose track. Yeah, you get married, you have a remarriage, you have adoption, you have a child that graduates, you have things moving on. Keep track of it and then do some planning. It doesn't take long. Get things in order in case something happens, because something's always going to happen. There's always going to be a crisis. There's always going to be something. I don't wish it, but it's the way of the world. Make sure your stuff is in order. So when you write down your priorities, again, you look at your priorities in your life, say, what's more important to you? What's the most important thing to protect in your life? Is it your assets? Is it the family members, your children? What things do you think about first? And also, do you believe your current setup reflects your real life relationships? Do things match? Or do you have nagging doubts? This is the place to write that. And of course, what matters when you choose decision makers, who would you have chosen to care for your children? Especially if you have children and you have a partner, a spouse, in your will or in your documents, you can have guardianship provisions, choosing who would take care of your children in case you and your spouse or partner pass away. That's very important. These are your children. And that's something that we always talk about when you make your will or your documents, who are your guardians for your kids, and then who are your trustees to manage the money for your kids. So they have enough money to go to camp, go to college, have private school, or deal with day-to-day expenses. So you set these plans up based on what your priorities are. And we're to help. This is what we do. So when you build a plan that reflects your life, again, it starts to get a lot easier. One thing I've learned is when you plan ahead, you get things organized, you remove all the debris, all the complexity, people that are making your life difficult, get rid of people that are not helping you achieve your goals. Yeah, you're building something that reflects your actual life. Because when you have a strong estate plan, a strong long-term care plan, you're protecting your partner, your spouse, the loved ones, your children. It's fantastic. You also ensure your healthcare decisions reflect your wishes, that whatever happens, there's a plan for it. You have the right person who can guide your healthcare and your procedures and your discharge. It's so important. Same thing with directing assets to the people and cause you care about. Maybe you have a charitable intent, and maybe this is a way for the people that you choose to direct money to the organizations, to the causes that matter to you. You may have pets. Have a pet trust built into a will or your own trust so that your pets, your cat, your dog, your goldfish, I'm being a little facetious, but it's, anything that you care about, you can have money set aside to protect and care for them. And of course, providing clarity during difficult times, because the biggest legacy problem is you leave behind, a family that is in discord, that doesn't get along, that fights. And that's a very bad legacy. If we can avoid that legacy and have the people you leave behind get along, maintain strong ties, have a great family and close relationship, that's a great legacy. And I always encourage that. What's your value for keeping your plan current? What's so important? Listen, when your life changes and your plan changes alongside of it, again, everything continues to evolve, and then it works smoothly for each step. If you don't go forward and you leave things the way they were without changing it, then you have bad results too. This is ongoing. Your life doesn't stop. You have to stay in tune. You stay up to date. Keep your brain sharp in that respect. Because again, if you get married or you get divorced, update your plan. You have a new child, a grandchild, same thing. Make this plan updated. Same thing with relationships, family structure. People come, people go. You may be in a strong relationship that ends. Update your stuff. Same thing with financial changes. You may get a windfall, inheritance from a parent. Take advantage of that. Have a financial advisor. Have a plan. Do estate planning that coincides with that. And same thing, if you go to a new state, if you move from New York to New Jersey or Connecticut or Oklahoma, make sure that whatever documents you have, especially we do a trust, it has a situs of trust clause. It can move with you to the new state. You may sell your home in New York, assets and proceeds stay in your trust, use that asset to then buy something in another state, that deed then goes right into your New York trust, and it still be okay. And we always encourage, of course, have an attorney in the new state review everything. It's good practice. So how do we work? I mean, this is, as we come to the close of this webinar, again, as an elder law trust and estates firm, estate planning firm, we try to keep things streamlined and simple because we know that nobody is ecstatic about meeting with a lawyer about difficult family decisions, difficult planning. So we want to keep this as simple as possible. Number one, after you make an appointment, we do a 30-minute case evaluation with an intake specialist. We have a letter of engagement once you agree to go forward. Then our attorneys and paralegals will do a design meeting, asking questions, getting specific ideas about what you want for your life. And basically, we're making your wishes come true. That's what we're doing. Not quite Walt Disney World stuff, but close. Number four, you review draft of your estate plan. You review the work that we've done. You examine it before you sign it. And then the finalization, the signing, the execution of documents, witnessing, recording deeds, everything that gets done that puts your plan into place. And then you have us. You have the Feller Group. You have our firm behind you as your life evolves. We're a phone call away. We'll help you. We're there for you. And that's what we do. We do this process every single day because we know that this is not something we want you to stress about. So when you put your reflection and your reflective notes in your workbook, again, if something happened tomorrow, who would make medical decisions for you? Where would your assets go? Where do you want them to go? And are your wishes clearly documented, or you haven't really done much? And if life changed tomorrow, would your plans still work as intended? Write this down, put it in writing. It makes a difference. And if you speak to us, these writings will help. Well, I want to thank you for all of your time and attention. Again, my name is Alan Feller. This is the Feller Group. We have our contact information. You can always call our main office, 845-621-8640. We'll help you. We'll set up appointments for you. And it's something that really, it's very important. It's a real major part of your life. And, I'm hoping that in the future, that when we do more webinars, we can really get a nice collaborative approach, because I think this is something that's really important. As far as Q&A for this session, what we'll do is, if you have any Q&A, you can definitely email us, email me. I can reach out directly to you because it's an important topic. And I know a lot of you have a lot of questions. So that's why we'll do this, and we'll continue it on an email chain, definitely. Anyway, thank you so much for being with us today. And I hope this is informative. I hope this really helps you. Take care.